Good evening, everyone. I'm Lee Softly, and as Dean of the University of Maine School of Law, I'm delighted and honored to welcome everyone to the 2020 Judge Frank M. Coffin Lecture on Law and Public Service. This year marks our 28th annual Coffin Lecture. And although it looks a bit different because we're gathering together via Zoom, there's a silver lining to this virtual platform. We have folks joining us from across the continent, Alaska, California, Canada. It's wonderful. And I'd like to extend a warm welcome to the members of the Coffin family and the Coffin law clerks who are with us this evening, as well as to the distinguished members of the main bench that are joining us tonight. Before we begin, I want to take a moment to acknowledge the very sad news that Judge Juan Torroella, a good friend of Judge Coffin and a fellow First Circuit jurist, passed away this week. Judge Torroella was 87 years old. He was the first Hispanic person appointed to the First Circuit, and he was still serving with distinction. In fact, I understand that he was scheduled to sit at the end of this week. The judge was well known for being a fierce supporter of Puerto Rico and a supporter of LGBTQ rights and women's rights. He will be very much missed. We turn now to the 28th Judge Frank M. Coffin Lecture on Law and Public Service, which provides us an opportunity to reflect on our own individual and collective commitment to doing justice in our society. Judge Coffin was a role model and an amazing friend. He was a true Renaissance man. He was an artist, an author, and an extraordinary jurist. His career included work as a private practitioner, service as a United States congressman, and his highly respected time as a judge of the First Circuit Court of Appeals. And through it all, he wrote and spoke prolifically about the importance of public service, and he was an unflagging champion of legal services for the poor. Judge Coffin was a staunch supporter of Maine law, and more than that, he encouraged young lawyers and professionals to pursue careers aimed at lifelong service to the public. Publicly and privately, he challenged all of us to pursue justice in whatever sphere of influence we might have, from grassroots projects to expansive institutional innovations. In keeping with Judge Coffin's exhortations, it is my privilege and honor to announce that tonight's lecture will be delivered by Lee Gallant, Deputy Director of the ACLU Immigrants' Rights Project. Attorney Gallant is a former law clerk to Judge Coffin, and through his work at the ACLU's national office, he is widely recognized as one of the country's leading public interest lawyers. Attorney Gallant's topic tonight is Challenging Immigration Policies, an inside view from an ACLU lawyer at the center of the fight. Our introduction speaker, Professor Samir Ahmed, will tell you more about Lee Gallant and his career. So let me introduce you to Samir. Samir is a clinical instructor at the Harvard Immigration and Refugee Clinical Program at Harvard Law School. He also serves on the board of Project Citizenship, a nonprofit agency which provides high-quality free legal services to immigrants all over Massachusetts. Samir earned his bachelor's degree in international relations from Stanford University, his JD from Yale Law School, and a master's degree in legal research from Oxford University, where he was a Marshall Scholar. Now, lest you think he spent all his time in libraries, he's also served as a senior litigation associate at WilmerHale and as a Skadden Fellow at the Asian American Legal Defense and Education Fund. He was previously an assistant teaching professor at Northeastern University School of Law. He served as a law clerk for Judge Patty Saris of the U.S. District Court for the District of Massachusetts. And what makes Samir almost a Maynard is the fact that he clerked for my friend and early mentor, First Circuit Court of Appeals Judge Kermit Lopez. Thank you so much for joining us tonight, Professor. The floor is yours.
Thank you very much, Dean Softly. I want to thank you and the University of Maine School of Law community for giving me the honor of introducing Lee Gallant this evening. It is also an honor to rejoin the Maine law community. In the fall of 2014, I had the privilege of teaching a seminar on immigration policy there while I was in Portland clerking for Judge Kermit Lopez. As you may know, Judge Lopez and Judge Coffin were First Circuit colleagues and friends, and Judge Lopez considers Judge Coffin a mentor. So getting to introduce Lee, who I am so fortunate to have as a mentor, and a law clerk to Judge Coffin himself, feels something like a family affair. And speaking of family, though I never met Judge Coffin, I did have the opportunity during my clerkship year to have lunch at the Coffin home with his wife Ruth and daughter Meredith, and I know that their notable warmth was also one of Judge Coffin's admired traits. I first met Lee in the summer of 2007 after my 1L year of law school when I was an intern at the ACLU Immigrants' Rights Project in New York. I was quickly introduced to Lee's meticulous and selfless approach to his work. In my first week, he assigned me to work with him and a paralegal to finalize a brief to the Ninth Circuit in a case, Al-Kid versus Ashcroft. Late into the night, after everyone else had left the office, we three remained as Lee reviewed and refined the brief to make sure it was just right. For those of you unfamiliar with the Al-Kid case, it was brought on behalf of Abdullah Al-Kid, then a young Black Muslim American man who was arrested by the US government in the aftermath of 9/11, detained for 16 days, shackled and held naked, even though he was never charged with any crime. The case made its way to the US Supreme Court, and in 2011, Lee did his best to convince the justices that Attorney General John Ashcroft should be found liable for creating the unlawful policy that led to Mr. Al-Kid's false arrest and imprisonment. The justices unfortunately disagreed, relying on the highly problematic doctrine of qualified immunity that has been heavily criticized in recent months for preventing people of color to obtain justice from harm committed by law enforcement. Now, while Lee has been on the forefront of some of the most important immigrants' rights cases over the past few decades, his work has taken on new significance since the election of Donald Trump as president. In almost every major anti-immigrant action of the Trump administration, Lee has helped lead the fight to ensure non-citizens receive the protections afforded to all of us under the US Constitution. A leading example was Lee's work to strike down the first version of the Muslim ban instituted just days after Trump's inauguration. That effort was particularly meaningful for me as a Muslim American civil rights lawyer with relatives whose lives have been harmed by the ban. Later, when the Trump administration began tearing young immigrant children away from their parents, Lee was also there. He has been the ACLU's lead attorney in their family separation lawsuit, which has ended the worst aspects of that policy. His work has led to over 2,000 families being reunited. While Lee has been a superb advocate in court, his commitment to his clients extend well beyond the courtroom. What you may not know is that Lee has actually traveled to Central America himself to search for parents who were deported while their children remained locked up in cages in the United States. And even when Lee isn't serving as lead counsel to challenge the Trump administration's most egregious anti-immigrant policies, he has offered to help lawyers across the country fight similar battles. Anyone who has tried to litigate an immigration case in federal district court will know that the government will try to dismiss it by asserting a myriad of complex jurisdiction stripping statutes. Lee is the national expert on those issues and has an incredible ability of making extremely complex legal arguments seem simple. In his matter-of-fact, straightforward way, he has convinced judges across the country that they do have jurisdiction, undoubtedly protecting thousands of individuals from deportation. For example, when the Trump administration tried to deport dozens of individuals from neighboring New Hampshire's long-standing Indonesian community, Lee was asked to join the case and convinced a federal judge in Boston to stop their impending deportation. It is impossible to overstate the role that Lee has played as an advocate for immigrants' rights. But perhaps just as important as his litigation work is his role as a mentor to young public interest lawyers. I know that Judge Coffin is admired, among other things, for inspiring so many of his law clerks to work in the public interest. Lee is certainly carrying on that tradition, not only at the ACLU, but also somehow finding time to teach law students. I feel fortunate to have been one of the beneficiaries of Lee's commitment. In addition to my experience as an intern, I again worked with Lee when I became an immigrants' rights staff attorney at the ACLU of Southern California. Although I am no longer there, we are still co-counsel in a case challenging the Trump administration's extreme vetting policies against Muslim immigrants. A few years ago, I conducted one of my first federal court oral arguments in that case. And despite everything else he was doing, Lee found time to send me an email to congratulate me on the argument and ask how it went. That reaching out, again, is reminiscent of what I know about Judge Coffin. Despite numerous accomplishments and accolades and exhaustive media attention, Lee has remained down to earth, self-deprecating, and attentive to the people around him. But don't just take it from me. Over the past few years, Lee has been interviewed by the media on countless occasions. And the following is a clip from probably my favorite appearance that captures both how well Lee describes legal issues for a lay audience and how he handles admiration with such humility.
And what happens when federal agencies don't uphold federal court orders?
We're trying to find out. One of the problems is the government's not sharing information. We have heard people were sent back. We don't know if it was right before the stay, right after.
What could happen if they don't comply with this order?
If they continue not to comply, then I think the court will really press them. But at the end of the day, the court always has the power to hold the administration in contempt.
Tell me about the stakes here.
If a government agency intentionally did not listen to a federal court order, that is as serious as you can get in America.
What are the odds that this is really just a last-ditch effort to avoid actually being president? Because I really feel like he is sprinting toward impeachment here. And lawyers like Lee will be nipping at his heels the entire way. I love you. I love the work you're doing. I think it's really important, but I really want you to take this in. Lee, if you come at the king, you best not miss. Understand?
Got it.
Without further ado, Lee Gallant.
So I had actually told Samir that in all these years, I have not got up the nerve to watch that interview, but Samir said he was going to show it anyway. So that's actually the first time I have seen that interview. Thank you so much, Samir, for that generous introduction. It's so great that you're here and that we've kept up with each other all these years. Thank you, Dean. Thank you, Maine Law School, the Coffin family, all my fellow clerks, everyone who had anything to do with this lecture. I cannot overstate how big an honor this is for me. I know I'm not alone in saying that the judge played an enormous, enormous role in my life. You know, he taught me about the law, but for me, more importantly, he taught me about life and how to carry yourself as a professional. And that is, I think, for me, you know, the major takeaway from my clerkship and all the time I spent with the judge. The last time I spoke with the judge, he told me how proud he was of me and all his clerks and all the work they had been doing. I think the one thing that he would be disappointed in is my work-life balance over the past 4 years. You know, as you all know, the judge was very big on leading a full, complete, broad life. And he was constantly telling us to go home at night, that the opinion was fine and that we shouldn't stay there all night and we needed to go on with our lives. I feel fairly safe in assuming that he would not be happy with the work hours I've been keeping the last 4 years. One of the things that's been keeping me so busy is the family separation case that Samir mentioned. And I thought I would talk about that tonight, in part because it's been in the news so much this last week, to the point of being asked, it would becoming a question at the last presidential debate, a question being asked of President Trump about the 545 families who the ACLU has still not found as part of the lawsuit. And in fact, today, some of you may have seen that Vice President Biden put out an ad about family separation and said that he would create a task force if he became president to deal with the families that have been separated. So given that it's so much in the news and that I've spent so much time over the last years, I thought I would talk about that in detail. Before I get into the details of the lawsuit, I just wanted to sort of make one point about some of the numbers that are flying around that some of you may have seen. We informed the federal court last week in our lawsuit that we have not been able to find the parents of 545 children who have been separated. What's being reported sometimes through confusion is that there are 545 children who are still separated. The truth is that there are many more families who are still separated, hundreds and hundreds more. The 545 are just the ones we haven't been able to find, but there are hundreds more that we have found and remain separated because the Trump administration will not allow the parent to rejoin their child in the US. So, you know, I thought I would just say that at the outset because there's constant reporting in the last few days about the 545 and the confusion, but it is way more than 545 who remain separated. And you know, overall, we put the number between 5,400 and 5,500 children who have been separated to date under the Trump administration's practice. So the lawsuit was filed in 2018, but in the fall of 2017, we began hearing that children were being separated from their parents. We were investigating. It was hard to get information. By the winter and by January, it was pretty clear that it was happening on a fairly large scale. And so we were putting together a class action lawsuit. And at that time, we believed that there were anywhere from sort of 300 to 500 families that had been separated based on reports from advocates and grassroots organizations on the ground. But we still hadn't directly talked to any of the parents ourselves. In the beginning of February, we heard that there was a woman who goes by Miss L, who became the named plaintiff in our case, Miss L v. Ice, who was in a detention center in San Diego and had been separated from her child. So I went out to visit her, and when I got out there, was shocked by what I had seen. And I've, seen a fair amount over my nearly 30 years at the ACLU doing this work. She was gaunt, had not been sleeping, and told me the story of what had happened, that she was fleeing for her life from the Congo, came with her 6-year-old daughter. It took her months and months to get here, sometimes walking hundreds of miles barefoot, begging for food, eating out of garbage cans. Finally made it with her daughter after roughly 3 months, made it to the San Diego border and went to a port of entry and applied legally for asylum, didn't cross the border illegally. And I mentioned that where she applied because there was a lot of talk, and still is a lot of talk, that the only people who had their children taken were those who crossed the border illegally. Well, she did not cross illegally. She went to a port of entry and said, I need to apply for asylum, she and her daughter, and they put her in a makeshift detention center for 4 days. And this is her recounting the story. And then one day they said to her, after about 4 days, they said, you need to come down to the immigration office. They brought her to the immigration office and said, your daughter needs to come in a separate room. The mother was brought into a different room. The mother was handcuffed. And at that moment, she said she heard her daughter screaming, Mommy, don't let them take me away. Don't let them take me away. Shrieking. The little girl was shrieking. They took the little girl away. They didn't tell the mother where they had taken her. They had ultimately taken her to Chicago to a government facility. The mother finally got to speak to the daughter, had no idea where Chicago was, why they took her daughter away. And by the time I got to visit the mother in San Diego, her daughter had celebrated her 7th birthday by herself in this government facility in Chicago. She had talked to her daughter only a handful of times, never by video, only by phone. Neither one fully understood what was going on or why the daughter was taken. And so at that moment, we decided that she was so desperate for help that we would file a case up just on behalf of her and then file the class action as soon as possible, because that was taking a little bit longer. And so we went into court and the government said, well, yes, we took the daughter away, but we had no reason to believe that the mother wasn't the trafficker because she didn't have birth certificates with her. And we of course said, but she took 3 months to get here. She was robbed of everything. The daughter looks identical to her. She was screaming, Mommy, Mommy, don't let them take me away. Why would you have assumed she wasn't the biological mother? And the government said, well, without the papers, we just had to take her away. And the judge cut through it all and said, well, did you do a DNA test? The government said, no. The judge said, you need to go do a DNA test right away. They did the DNA test, and of course, it was the biological mother. They were reunited. They were the first to be reunited. And for any of you that may have seen the documentary, The Fight, you saw the reunification at the end of the movie. And it was as emotional a scene as I have ever seen. In all my years at the ACLU, it was just sort of that raw emotion. And it wasn't just because they had been separated at that point close to 5 months, but I think neither one of them ever thought they would see each other again. They were from a little village in the Congo, had no idea what was going on, just had no reason to believe that they would ever lay eyes on each other again. And, they came together in this sort of embrace that was just unbelievably emotional and heartbreaking. So we then filed the lawsuit, the class action, and we alleged that there were 300 to 400, 500 people that we believed had been separated. By the time we had a hearing, the New York Times broke that there were probably 700 families that had been separated. We had the hearing. The judge ultimately issued an injunction in June of 2018 and said, this is a brutal, unconscionable policy. It's unconstitutional and it needs to end, and we need to reunite the families that have been separated. The government came forward with a list of approximately 2,800 families that have been separated. We were hoping that the 6-year-old girl of Miss L was an aberration, and the rest of the family's children will be teenagers. Not that that would make it, so much better, but at least they would probably be able to handle it slightly better. It turns out that many children were under 5. Some were 5, 6 months old who had been taken away. And we said we need them all reunited within 30 days and the children under 5 within 14 days. The government missed those deadlines, but ultimately for the parents and children who were in the US, reunited them, well over 2,000. And this is what was called the original class, these 2,800. But the government admitted that of those 2,800, 470 parents had been deported without their children. And some just, when we talked to the parents, just horrendous situations where the parent would be told, your child will be on the plane with you, don't worry. The plane would then take off without the child, and the parent would have no idea where the child was. So it became clear there were 470 parents sitting mostly in Central America, but some as far as Romania, Brazil, and a few other countries, sitting in those countries without their children. The judge said, you need to reunite these children also and find the parents. The government said, well, because they've been deported already, we don't think they should be part of the case. The judge said, absolutely not. This is Judge Sabraw in federal court in San Diego, said, absolutely not. This is even a worse situation because the parents may be sitting in other countries having no idea what's going on. We need to find these parents. The government said, well, we don't think they should be part of the case. And if you're going to make them part of the case, then let the ACLU find them. And so I said, we will find them and we will get people to help us. And so we formed a steering committee with the Paul Weiss Law Firm and 3 NGOs, Kids in Need of Defense, the Women's Refugee Commission, and an organization called Justice in Motion, which operates in Central America. And we said, we'll find them. Many other groups have also, and law firms have also helped. We ultimately found all 470 of those parents. The Trump administration said, though, that none of the parents could come back to the US. We ultimately got the court to order a handful of the parents to come back. Unfortunately, the court did not allow all the parents to come back. So that left the remaining about 440 parents with the horrible choice of either remaining permanently separated from their children or bringing their children back to the danger from which they fled originally, the sort of life-threatening danger. And there was a lot of talk about how maybe the parents don't even want the children if they're going to leave their children in the United States. And needless to say, nothing could be further from the truth. When I was in Guatemala, I talked to a father and he said, I can't bear the thought of never seeing my child again, but he's gang recruitment age. And if he comes back here, he's either going to be killed, forced into a gang, or end up in jail. And that would be even worse. So many parents had to make this agonizing choice. The parents with younger children brought their children back to Central America. The parents with older children, especially if they had relatives who they knew, allowed their children to stay in the United States. So those are parents that have been separated for years now. We're hoping we can ultimately get them back to the United States to rejoin their children here, given what they've been through, but right now they remain separated. We hoped that the 2,800 was the full scope of the damage done under this policy. But during the winter of 2019, an internal watchdog report from HHS revealed that there may have been many more children who were separated even before the 2,800 were separated, and that the government had never disclosed these families to us, or to the court, or to Congress, or the public. We went back to court and we said, Your Honor, an HHS report has revealed that there may have been many more children separated under a pilot program that began as early as July 1st, 2017, before what became known as the formal zero tolerance policy. The government said, yes, we admit that, but we don't think those kids should be part of the case because they were released from government facilities to foster homes or relatives before Your Honor's injunction. The court said, well, that's a completely arbitrary date. We're going to fine the families. The government then said, well, we want up to 2 years to give the ACLU a list of the names of these children, not to find the families, but just to give us a name of the list of the children who had been separated under this pilot program. The judge asked, why do you need 2 years? That seems exceedingly long, given that some of these children may be just toddlers and already separated for 2 years. And the government then candidly admitted what everyone was beginning to suspect and said, we just didn't keep track of the children and we're going to have to recreate it, go back through all of these records and manually recreate which children we took and separated. The judge said 2 years is absolutely too long. They're going to give the names to the ACLU on a rolling basis and give them within 6 months, have the final list. By the time we got the final list, it's the fall of 2019. Turns out that 200 of the children, of 1,556 additional children who had never been disclosed, were under 5 years old, toddlers and babies, and had been separated. That means maybe most of their life, all their life. Those families, though, were much harder to track down. Not only did we get a much later start, since we couldn't begin until we had the final list, fully begin until we had the final list in the fall of 2019, but because they had been separated so long ago at the beginning of the Trump administration, the information the government was ordered to give us, the contact information, was largely stale or useless. We found a few hundred of them through phone calls where the number hadn't become stale, the phone number hadn't become stale, the person hadn't moved. But ultimately, there were hundreds and hundreds of families who we were going to have to find through on-the-ground searches. And that was going to be led by one of our steering partners, Justice in Motion, who was working with human rights defenders in Central America. That is extremely time-consuming, extremely difficult, and very, very dangerous. When I was in Guatemala, a family said, well, you can come talk to us, but we can't get off from work. That's not a thing here in Central America where you can take time off for work for something like this, but you can't come after 6 p.m. because the gangs closed the entire town. So you're going to have a short window. So it's been a very, very difficult task. We were making progress and we had found a few hundred families by March of this year, and then COVID hit. And that search had to be halted between March and the end of August. It's now still not full scale, but at least it's at 30% ramp up. So we are starting to make some progress, but it's the parents of 545 kids of this group that was only disclosed to us because of the HHS report that are still missing. And we will not stop till we find every one of them. We can't put a timetable on it. The judge understands that we do not intend to stop. The government has said now, because of the public outcry, oh, we'll help you, but they have never given us any concrete, specific ways to help us. Vice President Biden has just said that he will help us if he becomes president, but for the moment, we are still looking for them on our own, and that has been something that we have had to do. And the longer it goes on, the longer the children are separated. And again, they may have been a year or two old when they were separated back in 2017. We had then assumed, hopefully, well, that's it. There's only 2 groups. But what quickly became clear is, notwithstanding the court's injunction in 2018, June 2018, the government was continuing to separate families. The government said, well, we know we can't systematically separate pursuant to a policy in light of the court's order, but we can still separate if the parent presents a danger to the child. And we said, well, we agree with that principle. Every child welfare agency in the country agrees with that principle. If there's objective evidence suggesting a parent presents an imminent danger to the child, then of course you need to remove the child from the home. But it's only where there is actually a real imminent danger with objective evidence. Turns out that the government had separated nearly 1,200 additional children since the injunction, based on things like the parent had committed a nonviolent theft of a few $100s 15 years ago, or had a DUI offense 10 years ago, or had illegally re-entered the country. The kinds of criminal history that would never satisfy a child welfare expert. And in fact, we had independent child welfare experts look at the list of justifications given by the government for the nearly 1,200 children. And they said maybe a handful would warrant further investigation and none would warrant automatic investigation. Unfortunately, thus far, the judge has not stopped those separations. So that's something we continue to fight. But all in all, the original class of 2,800, the additional kids found by HHS, 1,556, and then nearly 1,200 continuing separations brings it to between 54 and 5,500 children that have been separated. Obviously, an enormous amount. And of those, we believe at least 300 are under the age of 5. You know, obviously the numbers tell one story and tell a devastating story, but the numbers really tell only part of the story. And, you know, in some respects, I worry that the numbers, the aggregate statistics, and the abstract policy arguments sort of blur the human dimension of this. Each one of those 5,400 is its own story. Each child is their own story. And there are so many of these cases that are objectively horrendous. For me, I'm not even sure that the ones that are so objectively horrendous are the ones for me, or at least for me, that are the worst, that stick out in my mind. I think there's some cases that just stick out in my mind for whatever reason. You know, one little boy from Honduras, a 4-year-old boy, had glasses, and his parents were from very modest means, but they were able to scrape together the money to buy him a pair of glasses. They also scraped together the money to get him a glasses case. And the glasses case became the biggest thing in their life, because if the glasses broke, they might not be able to ever buy him another pair of glasses, and he couldn't see without the glasses. They came to take him away, and he was begging and screaming, "Don't let them take me away, Mommy, don't let them take me away." They took him away. Fortunately, he was wearing his glasses, but he wasn't able to go get his glasses case. So all day long, all the mother thought about is, can my little boy see? Will they give him a safe place to put his glasses? If they break, will he get him another pair of glasses? Just the kind of things that, you know, every parent worries about their child, but never in this situation. Another father told me that he had a 7-year-old son with him, and he knew they were going to take him away because he had seen other children being taken away. And he asked them, "Can I just have a minute to brace my son for what's going to happen?" He was from Romania. They didn't give him the minute. They just screamed out, "We're taking you." And the son is holding to his father's leg and begging for, "What's happening? What's happening?" And they dragged him away. Another one of our plaintiffs had an 18-month-old baby. They made her put the baby in the backseat of the car, strap the baby, crying and screaming, in a car seat, and close the door without letting her comfort the baby. They closed the door, and the baby is craning his neck to see his mother in the back, assuming that his mother was going to walk around, conditioned to us that his mother would walk around the car and get into the front seat. The car starts pulling away, and she's watching her little baby, watching her. Just one after another, children begging and screaming, and then pulling them out of their parents' arms. At one point, it got so bad that they would tell the parents they're just taking them for a bath or a shower, completely oblivious to the historic resonance of that. You know, and then I also think constantly about a family I met in Tijuana. I met the father and his 10-year-old son, who had been separated for 5 months. The father had been put on a plane without the son. The son had been flown to New York, had never been on a plane. The father wasn't even allowed to say goodbye to the son, much less try and explain what it would be like to be on a plane. We finally got them reunited through the lawsuit. And I met them in Tijuana and talked to the father. And when the father was finished talking, the son sat there very intently listening. And when the father got up to leave, the son came over to me, got up all his courage, and put out his hand to shake my hand and said, "Thank you for helping my family. Will you continue helping my family?" And I just think about what the kind of courage it takes for a 10-year-old boy to approach a strange man and to do that, and to have to thank a strange man for getting him back to his parents. For me, it's just those sort of little stories that are so heartbreaking. And it's not just, the reunification is obviously the first piece of it, but the reunification is not the last piece, needless to say. The medical community, everybody from the American Academy of Pediatrics on down the line, told us in the beginning of the case that this was going to cause real trauma to these children, potentially irreparable trauma. And that's what I saw throughout the case. One of the first families that we reunited, the mother told me her 4-year-old son just keeps asking, are they going to come and take me away again in the middle of the night? And that's exactly what the medical community told us was going to happen, that a deep-seated vulnerability was going to set in for these children. Because when a child is that age, the only reason they're not scared of the world is because they think their parents can protect them. And when the child saw that the parent couldn't protect them, when the child is being ripped out of the parent's arms and taken away, and the parent is just standing there helpless to do anything, the child's whole sense of life and protection and how they would remain safe in the world is just shattered. And so now we have thousands of children who just live with the constant fear that something bad is going to happen to them. One doctor, Dr. Shonkoff at Harvard, who is one of the leading experts on child trauma, explained it also, that what the child goes through while they're separated. I mean, this is once they're reunified, they have so much vulnerability, but while they're separated, he said, think about you as an adult, think about literally the 30 worst seconds in your life when you're the most anxious, most scared. Think about the intensity of that feeling, and then imagine it lasting every second for the time the child's separated. So if the child's separated for 6 months, it's literally 24/7 for 6 months. That's the way the child's feeling. That's the intensity. And the child has much less ability, obviously, to cope with any anxiety, much less that kind of severe anxiety. And he's also explained that it would restructure the brain. So it would be actually a physical change to the child's brain. And it's ultimately not just the children that were traumatized, it's the parents as well. There's such a feeling of guilt about what happened. A lot of the children come back, they were so young when they were separated, they come back and they don't even recognize their parents, which, obviously is earth-shattering for the parent. The child's taken at 6 months, they're brought back at 1.5 years. They don't recognize their parents. The other thing that's happened is when the child is taken away and they see their parent just standing there helpless to stop it, they come back and they're so angry at the parent. They're so resentful, understandably, because they don't realize that the parent could not have stopped the separation. So they come back and they say, didn't you love me enough to stop them from taking me? Why didn't you stop them from taking me? And the whole dynamic between the parent and child is changed, hopefully not forever, but that resentment and anger and feeling that the parent let this happen is weighing on the child. So one of the things that we're trying to do, and others are trying to do with another lawsuit and through a variety of advocacy, is to get the parents and the children mental trauma help. But it's obviously going to be difficult. We're hoping that that's going to be something, if there's a Biden administration, they will do, or will get it through the courts. There's already been some movement on that, but it's possible they're going to need years and years of trauma help because of what's happened to them. And so what I want to be clear about, though, having said all that, is I am not someone who views immigration law or policy as easy. My own feeling is that people can disagree, reasonable people can disagree about macro immigration policy. But what I do think about the family separation policy and a number of other policies enacted by the Trump administration is that they're outside of the spectrum of where reasonable people can be on immigration. I think there's a reason why no administration in the past, Democratic or Republican, has ever systematically separated parents and children. You know, notwithstanding what this administration is saying, it is unprecedented. And every administration has said two things. One is that contrary to what this administration is saying, it would not be a deterrent from families fleeing danger. And in fact, in the beginning of the litigation, when I would meet families, I would always ask them, would you have come anyway if you knew your child was going to be taken? And invariably, they would just shrug and say, what choice did I have? You know, the alternative was even worse, that my child or I could be killed in Central America. So it was never going to be a deterrent, and every prior administration knew that. But the other thing that people have said, again, both Democratic and Republican administrations, is even if it actually were a deterrent, there's just some things in the United States we don't do. There's just some things that are out of bounds. And I think that's why we saw such a public outcry around family separation when it first came out in 2018. And it wasn't just Democrats and liberals, it was conservatives and Republicans. It was Laura Bush writing an op-ed in the Washington Post. It was the Pope making multiple comments about it. It was conservative religious leaders. It was even Republican elected officials. It was the average person looking at their own children and feeling viscerally how horrible it was. And so the public outcry was enormous, and it was critical. I think every civil rights lawyer would tell you that ultimately any lasting systemic change we're going to make can't come solely through the courts, that there has to be a public movement around it. And I think with family separation, it's the first time that I have ever seen something approaching a real civil rights moment in the immigration area. And it was critical to pushing back the Trump administration. It was the first time with any domestic policy initiative they pulled back. I think it was important in court, and it was just generally important. But the challenge for us has been, how do we keep it in the news? I mean, there's been a resurgence recently. How do we keep it in the news, since there's still all these families that we're looking for that are still separated, that need trauma relief, but also there's so many other things that are not getting attention that the Trump administration is doing. And just a couple very quickly, one is called Remain in Mexico. And there are now 60,000 families sitting in Mexico in squalid, very dangerous conditions, waiting for their asylum hearings. The Trump administration, in an unprecedented move, has said, if you want to apply for asylum, you have to wait in Mexico. These are people who are not from Mexico, so they have nowhere to live. They're sitting ducks from the cartels who are just picking them off. A lot of them are living on the street. It's just a horrendous situation, but you see very little attention to it. There's also something going on now called the Title 42 process, where unaccompanied children, sometimes as young as 10, escape danger in their countries, make it by themselves to the United States, and now are being summarily expelled under the Title 42 public health laws without even an asylum hearing or talking to an attorney, under the pretext that it's necessary because of COVID. The administration, needless to say, is not taking those kind of precautions with respect to COVID in other areas. And what everyone has said, all the scientists have said, is it's possible to quarantine these children for 14 days if they need it. There's plenty of space, and they can't be summarily expelled, and we don't need to do it as a public health measure. It's blatantly illegal. These public health laws have been on the books since 1893 and have, again, never been used by any administration to expel families or children without a hearing. Congress has provided a way to deal with communicable disease in the immigration laws, and the Trump administration is completely bypassing it. So now we believe there are 14,000 young children who have made it to the border fleeing danger by themselves and been expelled within a matter of days, often held in secret in hotels on the border and then expelled without any asylum hearing whatsoever. I think that's going to be the real challenge for us, and has been the real challenge for us, is how do we actually get things out in the news? And, and it's understandable. There are so many issues in the immigration world. There's so many civil rights issues. And then, of course, there's just so many issues generally that it's hard for people to pay attention to everything. But, that has been one of our principal obstacles and challenges over these years, is how to keep these issues with the sort of horrific human consequences in the news. And it's also partly because the issues are complicated. The president has easy sound, reaches a lot of people quickly, and has easy sound bites. And sometimes for us to rebut them takes factual development and explaining various things to the public, and you're flipping channels and you hear me starting to go into a lengthy factual response to the president. That can be, you know, you keep flipping, right? And so take, for example, his first asylum ban, which we have gotten enjoined, but the president came out and said, I'm going to have an asylum ban. He went on national television, said, I'm going to have an asylum ban. And now people have to apply for asylum only at a port of entry. If they cross illegally, they can't apply for asylum. And so that's an easy, intuitive soundbite for the president. He reaches millions of people. They say, oh, well, the president's going to allow them to apply for asylum. Just do it lawfully at a port of entry. What's wrong with that? Telling them not to sneak across the border. Well, the truth is that Congress has explicitly put in the law that you may apply for asylum regardless of how you enter the country, even if you don't enter lawfully. Even if you enter between ports of entry and sneak in the country, you may apply for asylum. And there's good reason for Congress doing it. And there's good reason why every other country in the world does it that way. Sometimes the ports of entry are hundreds and hundreds of miles apart, and a parent with a little child can't walk those hundreds of miles to get to a port of entry. Sometimes you don't know where a port of entry is. Sometimes criminal gangs are forcing you to cross at particular locations. And sometimes you're just running for your life and you cross wherever you can cross. So what Congress has said and what international law says is you have to be able to apply for something. We are not going to send someone back to danger just because they cross at the wrong place. Well, explaining all that is difficult. And the president's quick tweet, what's wrong with applying for asylum lawfully, is much easier. So in addition to there being so many issues to keep on the map for the public, explaining them all is very difficult. The family separation issue, I think, hit people very viscerally and was much easier, but even that fell off the wayside to some extent for a while. And it's been very difficult for us to get some of the other issues on the table where we believe it's not simply a disagreement, a Democratic, Republican, conservative, liberal disagreement, reasonable disagreement about macro immigration policy, but where it's just really gratuitous cruelty. The other obstacle, you know, the other challenge for us over the last 4 years has just been the sheer number of policies enacted by the Trump administration. I would say that we are litigating at least 15 cases now. I mean, we have hundreds of cases now that we've brought in the immigration area against the Trump administration. But I'd say there's 15 to 20 now, which are so fundamental that in any other time, they would be literally the only case we thought about, the only thing that we're actually working on. That's how big they are. But almost every other week, the Trump administration is fundamentally restructuring immigration law and especially asylum law to the point where we've had to bring all these cases at once. And you know, it strains the resources for us, for all of the people doing it. And I think the administration knows that. So it's just been a battle to keep up with all their initiatives and to be able to get them those initiatives out there so the public can see exactly what's going on. It's been, you know, by far the busiest 4 years I've had at the ACLU in my nearly 30 years. And it's been an extremely busy 28 years, to say the least. So I just wanted to close by, I guess, two things really that are more directed at maybe the young people in the audience, the law students in the audience, and I don't know how many there are, but I'm gonna do it anyway. 2 points. The first is, I think, the importance of not getting overwhelmed. I think when things like this are happening and they're so big and there's so many of them just in the immigration area, but obviously across the board in so many different areas, there's a feeling of, well, I can't really stop all this, or I can't even stop one of these big policies, so it doesn't really matter if I get involved. Or you get paralyzed by thinking, which issue should I get involved? And they all seem big. And I think what I would say is just pick any issue and any little thing to do and do it. You, even if it's just tutoring one immigrant child, or getting backpacks for one immigrant child, or taking one pro bono case, or whatever it is, just do one little thing and you will feel gratified by it. Do not get paralyzed by feeling like, well, I'm not going to stop this policy. I can't do that, or there's too many things and it's not going to make a dent in it. Just do anything. Every little thing you do will make a dent. Any little thing, an hour a week of tutoring a child who was brought here and has been separated by their parents. If you're a law student in a clinic, great. If you end up at a law firm or at a law firm doing one little pro bono case, that's fantastic. But don't get overwhelmed by the sheer amount of it, because that's what I hear a lot from people, especially young people. The other thing I wanted to say has to do with being a lawyer and not being dismissive about the power you have as a lawyer, or will have as a lawyer if you're a law student. It's very easy to make jokes about lawyers, and they are very funny, but I really urge you not to be to underestimate your power and your importance. I mean, one of the things I think about almost monthly, and I've thought about monthly for my entire career, is something that happened to me in my first case, right when I started at the ACLU. It was a big national case, and the plaintiffs were in Texas, and I went down to Texas to meet with one of the plaintiffs, who was a young 19-year-old woman. And the person who was my liaison down there was a grassroots activist. And she and I were about the same age, mid-20s or something like that. And my Spanish was poor. And so she was going to be speaking Spanish and translating for me. And we went and met with the woman. And the grassroots organizer, again, someone, just my age, said to this young 19-year-old woman, the plaintiff, who had signed some form she didn't understand and signed away all of her hearing rights. And the grassroots organizer started by saying that Lee is down here from New York, and he is a muy importante, very important lawyer, muy importante abogado, very important lawyer, who's come down here to help you. And after the meeting, I was talking to the grassroots organizer, and I said to her very cavalierly, you should have said I was a muy importante abogado. And she just, smiled and indulged me. And a few weeks later, I began to think about it and realized that although we were the same age, how much wiser she was than I was, how much she realized that this vulnerable 19-year-old woman needed to hear that there was someone on her side, and not just anybody on her side, but a lawyer was on her side. And how different it is for someone like that in their relationship to the government than it is for us, and how scared this woman was, and how important it was for her to hear that she actually had a lawyer her side who was going to be her lawyer and her advocate, and was going to stand up with her against the government. And I think about that almost every month for the last 28 years or so, about never being dismissive. I mean, of course, laughing at the lawyer jokes, but trying not to ever forget how much power you have and how much you can actually do as a lawyer for vulnerable people. And so I would urge the young people, whether you're going to do public interest full-time, part-time, just here or there, to try and do any little thing you can do, and remember how much power you actually have with that law degree. So maybe I end there, and I know that there were going to be some Q&A time, so I will stop there, if that's okay. Thank you.
I'm going to catch my breath and and invite everybody else to take a deep breath, including Lee. That was extraordinary. I just cannot thank you enough for being here and for going through all of this again for us. We are so grateful to have you here. I'm going to speak on behalf of Judge Coffin, which one should never do, to say how proud he would be to have heard you tonight. This was pretty extraordinary, I think, for everyone who is here. And we all know how much you have on your plate. So the fact that you took this time to be with us is just an incredible gift. And we are so grateful. We're so grateful that we're going to let you go and actually get some rest. And to everyone who helped put this evening together, I want to thank my colleagues, the professors, Barbara Riegelhoff, Carrie Weiler, who's just a magician with all the technology, along with Samantha Scarf and Jennifer Crane, and so many people who helped. Thank you so much, Lee. I'm so grateful for your time. Everyone, be well, be safe. Good night.
Thank you, Dean.
Take care.